In today's episode, we explore developing and monetizing intellectual property assets of a portfolio company. How does a new company go about developing a patent portfolio? And why spend the time and effort doing it when your founders are probably hyper-focused on just getting a business up and running? What if they do everything right and the business still fails? What good are those patent assets then? Can you still monetize them? If so, how do you do it? Today on The Upside.
Welcome to Upside, brought to you by the private equity and venture capital team at Farella, Braun & Martel. My name is Erica Villanueva, and I'm a partner here at Farella. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the private equity and venture capital space. Again, welcome to Upside. We're glad you're here.
I'm Eric Olson, and I'm an intellectual property and business litigation partner at Farella, Braun & Martel. I'm here today with my patent partner and one of my favorite people to work with, Jim Day. Jim, thanks for agreeing to do this with me today. Is this your first time doing a podcast? I can admit that it's mine.
It is, Eric, and thank you for having me.
All right, Jim. So tell us a little about what your practice is like and your career trajectory that got you here.
Yeah, so I started my career as an engineer, working as an electrical engineer before becoming a lawyer. And then for the past 23 or so years, I've been a lawyer, litigating intellectual property lawsuits, mostly in courts around the country. I'm also admitted to the patent bar, and so I litigate patent disputes in the U.S. Patent and Trademark Office.
All right, Jim. So let's talk about why VCs care about the intellectual property of their portfolio companies. But maybe first you can tell us what we generally mean when we talk about what kinds of intellectual property a portfolio company might have.
Yeah, so there are different flavors of intellectual property. There are patents. That's something that is you apply to the federal government and it's issued based on an invention. There are trade secrets. That's one of the common examples is the secret formula for Coca-Cola. Nobody knows except a few people, and it's highly valuable. There are copyrights, which think of you can't just buy a book, make copies of it and sell them and keep the money. Trademarks, which is, has to do with branding. So a number of different types. And in my career, I've dealt with each of these, but really have focused on patents.
Okay, so let's focus on patents, since actually that's what I think most VCs have in mind when they talk about intellectual property with me. That's also what I understand is your most active area of specialization. So why are patents perceived as so valuable to venture capitalists when they are evaluating portfolio companies?
One of the reasons patents have value is you can generate licensing revenues from them. So you can go out to other companies that are using your invention and say, look, you're going to have to pay me a fee to continue using my invention because I have a patent that says I can otherwise prohibit you from doing it. And I could sue you if I had to. And we hear about huge licensing deals. You read about them. And we read about huge jury verdicts in patent cases with, substantial, gigantic, sometimes damages awards. And so that's one way that patents, have a value, this revenue stream and potential for, enforcement through lawsuits. There's some other things too. Having patents is a way to show that your company has value. If you have inventions that are worthy of patents, I think outside entities valuing your portfolio company can look at those and it contributes. They can also provide some protection. If your company is threatened with a patent lawsuit, you might be able to turn around and either countersue or try to, hopefully resolve the dispute by entering some sort of a cross license. So patents can have, benefit in a number of different ways.
Jim, it's expensive to file and prosecute patent applications, right? And aren't there fees associated with maintaining a patent if you're fortunate enough to get one issued? So is it really worth pursuing patent protection when a startup company is probably hyper-focused and super busy just trying to get their businesses up and running?
Yeah, I think that's a good question for, startup companies, new companies to consider. It is expensive. There are filing fees with the patent office. You can end up almost certainly paying some patent lawyer to help you prosecute the patent. But maybe even more, it takes time away from your business, right? You're going to need input from the engineers or whoever it is that are creating these inventions. And, every minute they're spending on a patent application, they're not spending on your new product. So there's a cost involved. But as I was saying, can be value generated. And so it's a balance you need to weigh.
So when should portfolio companies start filing patent applications, and why?
Frankly, I mean, it's a decision to make. Do you want to build a patent portfolio or not is a decision, because there is a cost. And so you weigh the costs with the benefits. But if the portfolio company decides, yes, this is something we want to do, we see the value is worth pursuing, you want to do it early. So what you need to know is you can't wait until after the fact. You can't launch your new product, have it on the market for years, and then decide, you know what, we'd like to get some patents. By then, it's likely too late. And so this is the sort of thing that you need to think about, at the same time that you're working hot and heavy trying to get your product out the door, because if you wait too long, it may be too late to build your portfolio.
What are some of the biggest mistakes you see small startups make when it comes to patents?
Yeah, sort of for the same reason. I think the biggest mistake you can make is to not think about it. So I'm not saying every company needs to build a patent portfolio, but if you don't think about it and you realize 2 years down the road, 3 years down the road, wow, we have a bunch of great inventions that are out, we've put out in the market, it's probably too late now to apply for patents. And so the mistake is just not to consider it, and consider it early and develop a strategy. And then if your strategy is to develop some patents, it's to put at least some minimal policies in place to make sure the engineers and others who are inventing identify those inventions, get them to whoever it is that's going to file the applications.
So Jim, you and I have both been involved with patent litigation funding, and frankly, you more than me. I think it's something that maybe venture capitalists have heard about, but maybe don't really understand it the way that you and I do. Let's take a hypothetical. Let's say you have a company that's ceased operations, it's failed, but it still owns some patents, and they think other bigger or more successful and profitable companies are infringing the patent. What can they do? And let's say there's not money to hire counsel to assert the patents. How do they go about getting litigation funding? What's the process? Where's the first place to go? How does the funder evaluate your case? I know that's a lot of questions, but...
Well, let me start by putting litigation funding in some context. So traditionally, if you were any patent holder, you have a patent and you see that some other company is using your invention, you could take a bunch of your own money, hire lawyers, and go out and sue them. Patent infringement lawsuits are very expensive, and so you'd need to have a lot of money to do that. The other option would be to find a lawyer who would take your case on a contingency, which you've probably heard about in lots of different contexts, is where the lawyer essentially works without charging you fees, but then takes a big chunk of any ultimate award you might get. Well, litigation funding is something sort of in the middle. Litigation funders are relatively recent in the patent area, but it's companies who sit on a big pot of money and they're willing to invest in lawsuits with the understanding that they're going to pay either some fraction of the legal fees or all the legal fees. But then if you get a big recovery, they're going to take a big chunk of that recovery. That's what we're talking about.
Okay, so you haven't just litigated cases that are financed by litigation funders, right? You've actually done diligence for them. What does that entail?
Yeah, so imagine these companies are contemplating very large investments in something that's inherently speculative, civil litigation. I mean, you can never know how that's going to turn out. And they're considering that investment in a way that it's sort of an all or nothing proposition, because if you lose the case, they don't get paid anything. These types of loans, generally at least, are non-recourse loans. So it's an investment where the upside can be very big, but the downside could just be zero. And so the companies that I know do a good job looking into these cases before they agree to invest anything. And that, includes due diligence. So like any big investment, they want to kick the tires on what they're potentially getting into. And that can include talking to someone like me or another patent litigator or patent lawyer to sort of understand the case. Now, ultimately, we're just providing information to someone else who's going to make a decision about an investment. but not everybody knows all the ins and outs of patent lawsuits. And it can be helpful, I think, to point out risks, potential benefits, make sure they understand some of the ways that you can win or lose these types of cases based on looking at the patents and other relevant aspects of a particular case. So that's something that I have done in the past.
To your point about this being an all or nothing proposition, it's been my experience. Litigation funding money is some of the most expensive money there is. I don't know if you would agree with me on that, but I think you would agree that it's expensive money. And if you do, why is it so expensive? What could you tell the listeners about what kind of waterfall they can expect if there is a recovery at the end of one of these patent litigation lawsuits?
Yeah, so it is relatively expensive money in my experience. But again, it goes back to this, it's a binary investment. The litigation funders, or in general at least, ideally, they're either going to get some multiple of what they invested or they're going to get zero. And if zero is one of the possible outcomes, then you want the upside to justify that kind of a risk. And so the funding that I've seen or that I'm aware of generally has something like that. If we invest a certain amount of money and prevail in the end, we're going to want to get a significant multiplier on that amount of money. Now, it'd be cheaper to mortgage your house, right? And just get a bunch of money and go litigate. The difference is if you take a mortgage out from the bank, you got to pay it back whether you win or lose. And so this is just a different model where the funder is taking a ton of risk. And so I think, reasonably, they're looking for a real big upside if everything works out the way that, the client and they hope it does.
So when I think about why this is expensive money, I agree with everything you said. But I also think about it from the point of view of the plaintiff company itself, the company who has the patents but doesn't have the cash to file a litigation, asserting the patents, and or can't find a lawyer who will take it on contingency. Even though the money may be expensive and you may have to share quite a bit of the recovery or even all of the recovery with the litigation funder, it still seems like there's only an upside for the portfolio company because, again, if you're not putting anything out, all there is upside, no downside.
Yeah, I think that is the value proposition that litigation funders are offering. It's sort of, yes, it's expensive money, but if your alternatives are to, take a smaller fraction of a big number or take zero because you can't enforce your patents at all, it's better to use the funding and, in an ideal case, get a big recovery and share it. And so I think that is part of the value proposition. I do want to note, I commonly the funders will want, there are hard costs of litigation. And so it may not be entirely a zero input by the client. There might be some, cover expenses or things like that. But I completely agree with you, Eric. That's the value proposition. You can either not litigate and get zero, or you can use this fairly expensive money, but it gets you into court. And the idea is it would allow someone who doesn't have a war chest to, litigate a valid, good claim against the company that otherwise would never be brought.
Right. So, Jim, let's say there's not an opportunity for litigation funding for whatever reason, and still the business has failed. What good are the patent assets then?
First of all, patents are not only valuable for litigation. That's one avenue for trying to generate revenue based on patents, but it's certainly not the only one. You can convince companies to pay a license fee if you have valuable patents on an invention that they're using without necessarily going to court. But let's say you develop your patent portfolio, great ideas, good inventions, but the business doesn't succeed and you're near end of life. You can sell patents. They're an asset that can be valued and sold off. In the last couple of weeks, there was news about BlackBerry that shut down a big part of its business. Short time after that, sold reportedly a big chunk of its patent portfolio for $600 million. That's not a startup that failed. It was a very successful company that seems to be winding down, but those patents were worth a lot. The other thing that we've seen that companies do sometimes is if your operating business is failing, some companies sort of pivot to become a patent licensing business. So you take your patents and you go out in the world and you look for companies that you think are using your inventions, and you try to encourage them to pay you a license fee. And if they don't, and you really think they're infringing your patents, that can lead to a lawsuit. And we're sort of back to the point of perhaps litigation funding is the way that you do that.
Yeah. Any final thoughts on how portfolio companies should be thinking about investing in patent assets today or trying to monetize the ones they already have?
I think I would just go back to a point I made sort of early on, and that is you need to think about your strategy. Think about whether, I would encourage VCs to encourage their portfolio companies to consider your patent strategy. Are you going to apply for and build a portfolio of patents or not? I mean, there's not going to be a one-size-fits-all answer to that question, but it's something that you ought to think about, make the decision, knowing that if you choose not to develop a patent portfolio, you may not be able to do it later down the road after your product is on the market and either a wild success or your business is winding down and you wish you had a bunch of patents to try to generate some revenue or to sell off or whatever it might be.
That's it for today. I'm Eric Olson with my colleague, Jim Day, and you've been listening to Upside by the private equity and venture capital team at Farrell, LeBron & Martel. If you have any questions about what we've talked about or suggestions for topics you would like for us to discuss, please email us at upside@fbm.com. That's upside@fbm.com. Thank you for joining us. Until next time, take care.